Welcome to Divorces Schmidt, a family law series. In this episode, I will discuss how the family law courts determine who gets to keep the family pet when a married or de facto couple separates. Australia has very high pet ownership rates. The RSPCA's website cites statistics from Animal Medicines Australia, which showed that in 2022, 69% of Australian households had a pet. The most common pets were dogs, which were found in 48% of Australian households, followed by cats at 33%. Those of us who have them often consider pets to be part of the family. People have strong emotional attachments to their pets, and many people treat them as if they were their children. However, pets are not children as far as the law is concerned. The full court in the 2022 decision of Grunseth and Whiten said, "As much as it will pain pet lovers, animals are property and are to be treated as such. Questions of attachment are not relevant, and the court is not in effect to undertake a parenting case in respect to them." So the family pet is, in the eyes of the law, just another chattel. In most cases, the pet is unlikely to have great monetary value, so it is rather sadly akin to a household item like a TV or a washing machine. Given that a family pet is an item of property, the clean break principle found in sections 81 and 90(S)(T) applies. In Davenport and Davenport No. 2, Judge Tonkin observed that the court had no jurisdiction under Part 8 of the Family Law Act to make an order for shared custody of a dog. In the recent decision of Arena and Arena No. 4, a father in a parenting proceeding sought orders that the family pet move between the parties with a child, contending that the pet provided therapeutic value to the child who had special needs. Final property orders had already been made between the parents, and they provided for ownership of the pet. There, Justice Curran, with reference to Grunseth and Whiten and Davenport, determined that the court did not have jurisdiction to deal with the pet in parenting proceedings. So how does a court decide who gets the pet? The determination as to who gets to keep a chattel, including a family pet, is ultimately a discretionary one. A reasonably recent example of a family law pet dispute is Judge Boimel's 2022 decision in Barese and Arico. The matter involved a modest property pool of about $147,000 and a dog, which the parties had acquired around the halfway mark of a short relationship of around 4 or 5 years. Following separation, the dog remained in the wife's care. The husband tried at least a couple of times to take the dog from the wife. One of those occasions involved breaking into the wife's home, for which the husband was arrested and ultimately served a prison sentence. There was no agreed monetary value for the dog, but on either party's view, the value was modest. Her Honour determined not to include the dog in the asset pool. Judge Boimel referred to the wife's evidence that she had purchased the dog and that she had paid for veterinary services, including desexing, for registration, food and toys. The husband disputed this, asserting that he had purchased the dog. Her Honour held that, while there is a dispute about who paid for the dog and how much the dog cost, those details are of little consequence. The circumstances of the purchase of the dog is not in itself determinative of ownership, nor does it determine the future ownership of him. Both parties have a sentimental attachment to the dog, but that is also not determinative of who should retain him. The husband's tenacity in endeavouring to have the dog in his care, in my view, does not determine that he has a better entitlement to the dog than the wife. Her Honour found that the wife had made significantly greater financial contributions to the dog, had cared for the dog, and was the registered owner of the dog. Her Honour held that, given the wife's financial expenditure on the dog and her maintenance and care of him, the orders include that she shall retain the dog. The full court in Grunseth and Whiten suggested an alternative approach, which I imagine would be taken by many animal lovers as an affront. The full court there suggested that if the ownership is contested, there is much to be said for each party making a blind bid for the pet, with the highest offer accepted and taken into account in dividing the property. All in all, the family law landscape in relation to pets is likely to be an upsetting one for many parties. The Family Law Act makes no specific provision for pets, and they are given no higher status than white goods or couches. Whilst each matter will be determined by the court on a discretionary basis, the published cases suggest that factual matters such as registered ownership and financial contributions to the upkeep of pets can be important factors in determining who ultimately gets ownership of a pet. I'm Johannes Schmidt. Thank you for listening. I hope that this discussion has been of use to you. If you'd like to be notified as I release further episodes of Divorce with Schmidt, please follow me on your preferred social media platform, subscribe on YouTube, or subscribe on your favourite podcast platform.